My name is Greg McGill. It's McGill, and the firm is McGill Law Firm. I'm an attorney in Arizona. I've been practicing in Arizona for 34 years, and my practice concentrates principally in real estate and commercial transaction law as well as litigation. The practice, occasionally it will dovetail into related areas. For example, forming corporations, limited liability companies, development agreements, consultation with builders and developers. The litigation side of the practice is about, I would say, 60 to 70% of the practice is litigation. Out of the litigation area, most of the cases are in state court, although periodically I have litigation action in federal court. Most of the litigation is in the area of contracts, torts, things of that nature. Actually, I guess there were a couple of reasons I decided to become an attorney. One was the practice of law seemed to be the area that most interested me when I was in law school. I went to law school at the State University of New York at Buffalo in upstate New York, and I majored in economics, and then I got a master's in business administration and MBA. And when I was going through the master's program, it became apparent to me that I wanted to get more immersed in the law, so to speak. And I have an older brother who's a bond lawyer in New York, and he piqued my interest when I was in undergraduate. My assistance to the clients, that the best features that I bring on behalf of my firm, on behalf of LegalMatch, and I've been with LegalMatch for many years now, and it's been quite successful actually. But I would say that the principal reason for my success with the clients is it's not only the results that I bring, and in litigation I have to say you can't win them all, because sometimes in litigation sometimes it's just the best metaphor is poker. I mean, you're just dealt a bad hand, and you do the best you can with it. If the hand is really bad, then you wouldn't be in litigation. But sometimes you're dealt a hand that just you do the best you can. You can't win them all, but the ones that if you don't think you can prevail, then you really gotta do a good job of trying to settle a case and get a half a loaf is better than none. In litigation and civil litigation, a lot of cases settle for that reason, because you're at the end of the day you're weighing the risk of going to trial and the uncertainty and the additional attorney's fees to the client. You have to weigh that against the certainty of a settlement. And I tell clients that the certainty of a settlement, if you can get half a loaf versus continuing to pay attorney's fees with the expenditure of time and then the risk, and there's no guarantee you can prevail, a lot of times that's enough for the client to undertake a business calculation and decide to settle. But there are a lot of cases where they decide not to settle and they prefer to go all the way and go to trial, and I'm happy to do that. So one of the principal benefits that I try to bring to the clients that is quite successful is, I move that case as fast as I can move it and get it to a point where the client has to make a decision whether they want to go to trial or try to settle a case. And that's usually after about 3 or 4 or 5 months, which is, in the legal world, that's relatively quickly. And I think a lot of clients appreciate that, because at the end of the day, you're trying to get justice, but you have to do it economically. It has to be done economically. So I try to communicate with the client, have close communication so the client knows what's going on, and then at the appropriate time, which is usually about 3 to 5 months in, the client, with my advice, naturally, they have to fish or cut bait. Do they want to, they want to cross the Rubicon, or they want to try to settle a case? And in litigation, that approach is typically welcomed by the client. They appreciate that because of the speed with which they get to that decision where they're going to get half a loaf or roll the dice and go to trial and see if they can get the full thing. But that approach is typically in litigation is universally welcomed by the client because it takes into account the economics of the case. Well, this firm, it's a boutique firm, and its focus is on state and federal court litigation and contracts and torts. We do quite a bit of transaction law here as well. We form limited liability companies, corporations, partnership agreements. We advise builders and developers on development agreements and various issues regarding contracts and lien priority rights. We also will do trusts, living trusts, and powers of attorney, and we also just general consultation in the area of contracts, torts, fraud claims, negligence, both transaction and litigation. And again, the litigation, it's interesting because in this firm, we have the ability to go either in state court or federal court. Most litigation cases here in Scottsdale, Arizona are filed or defended in Maricopa County in the state superior court. But occasionally, depending on the issue, because there may be a federal statute or a federal question, it's more appropriate to go to federal court. And so we do that, and we have done it for quite a while.